Walking in, we were just counting the number, and I think we are we are getting closer. Hopefully, by now, the front desk can confirm that we are doing well. Okay, honorable members, I have learned about the passing on. Yeah, I was just about to say that I learned about the passing on of Mr. Nekundi Senior, the father of the Honorable Veiko Nekundi, the Deputy Minister of Work and Transport, on the 14th February 2025. I herewith express our collective heartfelt condolences to the Honorable Nekundi and the entire family. May the Almighty God give him and the family all the necessary strength to overcome this great loss. May he rest in eternal peace. Honorable members, we continue with the main part of the agenda. Any petitions, reports of standing and select committees, other reports and papers, notices of questions.
An urgent one to the Minister of Justice. But let me first dispense with two written questions. And unfortunately, the Minister is not around. But as the Speaker usually says, it's for record purposes, it will still be entered into. But before I ask the question, Honorable Speaker, this is one of the few issues that I'm really a little bit disheartened by it, because it concerns someone that I hold dear, and that is the late Professor Burumba Kerina. So it's just unfortunate that I have to ask this question directly to the Minister, but I will ask. I hereby give notice that on Thursday, 27th of February 2025, that I will ask the Minister of Agriculture, Water and Land Reform the following questions. Dear Honorable Minister, I have in my possession an allotment letter of a farming unit, Renete number 232 Unit A, in the Commerce region, so granted on the 28th of the 7th month, 2016, to the late Professor Burumba Kerina. This letter then leaves no ambiguity as to the allocation of this farming unit to Prof. Kerina. What is disturbing, however, is the fact that Prof. Kerina kids were told to vacate the farm by official from your ministry recently. Quite interestingly, in an allotment letter signed by then Minister Honorable Utoni Nuyoma and the Land Reform Advisory Commission chairperson, the following paragraph was highlighted in that letter. And I quote, "You are required in terms of the provision of the Agricultural Commercial Land Reform Act, 1995, Act number 6 of 1995, to take up effective occupation of the state farming unit, either personally or through a manager in full-time employment of yourself within 30 days of receipt of this letter. Failure to take up occupation within 30 days or such period as the Minister might grant will result in a cancellation of the allotment and subsequent allocation to another beneficiary." This to me clearly confirmed that this farming unit was allocated to the late Prof. Kerina, and because he took possession of the farm within a stipulated 30 days period, he indeed have complied with the provision of that act. Honorable Minister, however, surprisingly, officials from your ministry in their written communication to the kids stated that because Prof. Kerina did not sign a title deed before his death, they must vacate that farm. Honorable Minister, is this not contradictory with the said act? The act, as highlighted in the allotment letter, only speaks to take possession of the farming unit within 30 days after allocation. There is nothing in that letter that speaks to come and sign a title deed within 30 days of allocation. Why would a person sign a title deed on a land that is leased to the person for a period of 99 years and which remains state property? And why taking so long for the lease agreement, if it exists, if it should be signed? Because remember, Prof. Kerina, the late, got the farm in 2016 and he died in 2021. How many years are those? 5, 6 years? If indeed it must be signed, why did it take that long for the ministry to approve Prof. Kerina to sign the title or the lease agreement? Surely there is something fishy and clandestine going on, where some people, as we are informed, and luckily the minister is here, but I will not start, he will just have to catch up. Surely there is something fishy and clandestine going on where some people, as we are informed, some of them are honorable members of this house, conniving with some officials within the ministry and at the Commerce Regional Council to rob these kids of their rightful benefits of the said portion of the farm so that they can be resettled there. And I'm not making wide accusation here. I have concrete evidence of some of the members in this house that are behind this. And I'm protected by parliament immunity as well. And this honorable minister needs your urgent intervention to stop it forthwith. Equally, in a state allotment letter, it clearly stated, Honorable Minister, I'm asking a question regarding the late Prof. Kerina farm that is now in dispute, just for you to be able to catch up. Equally, in a state, who say Master start again?
No, please.
Oh, I would love to do that.
No, please.
Equally, in the state allotment letter, it clearly stated that in point 7, that in the event of your insolvency, liquidation, death, or mental incapacity, the land allocated reverts automatically to the state, whilst awaiting the appointment of an heir, trustee, or tutors, as the case might be. Honorable Minister, quoting from the above highlighted paragraph in that letter, is it not common cause that after the death of Prof. Kerina, the natural course of events should have been the process of appointing of an heir of the said portion of the land, who must be the kids or wife of the deceased? Is it not the current scenario that we have so many farms that have been allocated to people who have since passed away, but upon their death, their spouses, kids, and family took possession of the said portion and are living there until now? So what is the difference with Prof. Kerina, and why should these kids and family be told to vacate this portion of the farm? Honorable Minister, considering the role the late Prof. Kerina played in the liberation struggle of Namibia, is it the way the Namibia government should treat this or his surviving kids and family? Honorable Minister, this is an issue that really needs your urgent attention and intervention before you vacate your seat. As a country, we owe that much to Prof. Kerina. Honorable Speaker, in conclusion, as to the question that I have asked here, let history record that should this stand and this farm is taken away from his children, Prof. Kerina will go down in history as a man who was never accorded his rightful recognition in his own country while he was still alive, and who was robbed of his inheritance in death as well. He was even denied his rightful burial place, which was in Okahanja, next to his mentor, Chief Jose Akutako. It seems Chief Jose Akutako prayer will forever describe Prof. Kerina's struggles as he left, but the beds of the earth have a resting place. Regrettably, his children will still not have a dwelling place they will call their own, even after his death, after he fought gallantly for Mother Namibia freedom. I so move.
Thank you.
On the other question, Honorable Speaker, still directed to the Minister of Agriculture, Water and Land Reform, I hereby give notice that on Thursday, 27th of February, I will ask the Honorable Minister the following question. Honorable Minister, there is a long-standing issue of generational farm workers, especially in the Commerce region, that seems to be unresolved 35 years after independence. It is not a secret that the Komani, is it Komani, right? Yeah, Komani people still struggle until today to have a decent grazing place and a portion of land that they can call their own. However, the issue of generational farmers remains a serious problem, especially in the Commerce region. Honorable Minister, are you aware that many farmers continue to treat their workers badly, despite the Cabinet directive to take cognizance of the resolution of the Second Land Conference pertaining to generational farm workers? The farm owners continue to treat their employees badly. Honorable Minister, are you aware that last week, a generational farmer, Mr. Gerson Sani Danap, was fired by Mr. Danny Bota of Farm 352 Duon Clough when he turned 60 years of age, with a so-called pension payout of 10,000 after working for him for 41 years. However, Mr. Gerson did not get the whole 10,000, Honorable Minister, of the so-called pension. As from the receipt I obtained, the owner, Mr. Bota, had the audacity to deduct from his amount as follows: grazing 40 goats, 2 donkeys, 1 horse. In 1 month, he deducted 3,500, Food supply to his wife in his absence, he deducted a 1,000. Transportation that he got Mr. Esther Hazen to transport, 4,200. So the deduction was 7,500. So this poor man, Honorable Minister, from the so-called 10,000 pension after working for 41 years, went home with only 2,500. Honorable Minister, Mr. Gerson Sani Danep, a pensioner who have raised both Mr. Bota and Mr. Esther Hazen as kids, who worked 23 years for the late Mr. Fanny Bota, the father to Danny, and who worked for 23 years for Mr. Danny, left the farm in which his father was buried with only 2,500. He was thrown in a corridor with a few goats here with his kids and wife. My question, therefore, Honorable Minister, are the following. Is there anything that the Minister can do to assist Mr. Gerson Danap to be resettled somewhere? When will the government put policy and procedures in place how employers must treat their generational workers at the farms around the country? When will the government step in and direct farm owners to give a piece of land to their generational farmers to settle in? How long will the government turn a blind eye to the suffering of these generational farmers? What happened to the petition the Komanin community handed over to you, Minister, on the 4th of November 2024 regarding this issue of generational workers? Can the Minister confirm or deny that many farmers in Commerce region have multiple farms, while the community and the Komanin Traditional Authority has no land? Can you confirm that the farmer at Baumgartsbreg owns 5 farms, while the people in Dodabes, now poor in the vicinity of this farm, complains of systematic displacement and land disposition? Finally, Honorable Minister, the community alleged that you bought a farm, Groot Corasis Plus, for Komanin people in Omaheke region without due diligence, as they claim there is no water and water potential on that farm. However, you bought this farm for 33 million. Is that true, Honorable Minister? Now, having done with that, Honorable Speaker, can I now quickly turn to my urgent oral question to the Honorable Minister of Justice?
Yes.
Honorable Minister.
Well, it depends on how.
The gist.
The gist of it.
Okay. The gist of the question relates to an urgent matter which I can agree that the Minister will also find it very urgent, the shortage of magistrates in our country.
Okay.
Honorable Minister, reports have it that we have a crisis as far as our magistrates are concerned in our country. Reports have it that since October last year, there are magistrates that have been interviewed, and there is no deployment or appointment yet up to date. And especially the northern part of the country is really faced with shortage of magistrates, but not only the northern part, but all over, where you have magistrates that are commuting between towns to go and attend to court cases. And Honorable Minister, you know that magistrates are the cornerstone of our legal system, especially on the grassroots level. And obviously, as law practitioners, when they have to listen to cases, obviously they have to apply their minds. But apparently, in regions, these magistrates are dealing with civil, maintenance, traffic, domestic marriages, and even children court cases. They are so overworked. Honorable Minister, is this not a potential hotspot for justice denied, where perhaps magistrates might take over to dispense with cases where they are really overworked, where they cannot really apply their minds concretely to the cases before their hands? And if the minister do agree with me on that one, what are the remedial issues, processes currently to be able to address this issue that seems to be really getting out of hand?
You have really conveyed the essence of the question. Thank you very much. Honourable Minister, any update on that?
Thank you very much, Honourable Speaker, and also thank you, Honourable Kawendenge, for that important question about the state of the administration of justice more generally in the country, but also the conditions of our magistracy. I want to agree with you that there is a challenge around the number of presiding officers that we have across the country, and also that impacts on specifically the delivery of justice in some areas of our country, but I think also generally. I want to clarify and say the following. Firstly, the magistracy falls under the office of the judiciary. The Minister of Justice is, in a way, the voice of that institution in the National Assembly. And it's for that reason that I'm answering the question. The magistracy is also managed by a magistrates commission, which is responsible for appointment, recruitment of magistrates under the direction of the Chief Justice, the chairperson of the Magistrates Commission, and the Executive Director of the Office of the Judiciary. I can tell you, I don't know when the issue specifically about the lack of magistrates was raised with you, but as of last week, I signed a number of appointments of magistrates. One of the challenges that relates to magistracy more generally is the fact that there are other equally competitive opportunities available to judicial officers. So what you would find is that there is a lot of mobility within the judicial setup. So you would have people continuously apply for new positions when they become available, obviously for better benefits. People would leave for private sector. People would even be appointed into positions higher than where they find themselves. What I do also recognize is that over the years, the population in Namibia has increased tremendously. We now stand at 3 million. We were 1.4 in 1990, and so we have perhaps not at the same pace increased court infrastructure and judicial officers. We have, though, I can tell you, taken on accelerated reform activities to increase the number of courts in the country. I have elsewhere provided an update on where we are with that, where we've opened up courts, and the plans that we have for the next financial year. The Minister of Finance will agree with me. Just 2 weeks ago, the Office of the Judiciary made an additional request to increase and also improve on the conditions of service for magistrates, so that they are, even if they are not at the same level, but that they are sufficiently satisfactory for magistrates to remain in the positions that they are, particularly retention. So, as I conclude, Honourable Speaker, we are appointing more magistrates. We have done so over the past 2 years in a bit more targeted and an increased fashion. Secondly, we are building more courts. Thirdly, we are working on a project to improve the conditions of service of our magistrates so that we are able to retain them. Agree with you that that space in terms of access to courts impacts on the delivery of justice, and that is something that we recognize as a government, and we are doing something about it. Thank you very much.
Thank you very much. Well said. There was a little issue that I wanted to share with the Honourable Kawandeng when you posed a question from the Honourable Minister of Agriculture relating to the farm workers. I'm assuming that all employers in the agricultural sector on farms, they are required to make sure that the workers are covered in terms of social security. And if you are to vacate your employment, I'm assuming you are entitled to have that benefit. And people are not thrown away, but they live with social security. Not everybody. Okay. I'm going to leave it at that. Honorable Didier Hart.
Thank you, Honourable Speaker. Honourable Speaker, I hereby give notice that on Thursday, 27 February 2025, I shall ask the Minister of Education, Arts and Culture, Honourable Anna Esther Ipondoka, the following. The fact that grade 11 serves as an exit point for learners in Namibia is problematic in itself because it increases youth unemployment, which further gives leeway to other social ills. As announced by the Education Ministry in January this year, 28,726 learners out of 40,757 learners who registered for the Namibia Senior Secondary Certificate level examinations, which represent 70.5%, did not meet the requirements to progress to AS levels. This is a worrisome number of learners left on the streets, as many tertiary education institutions don't admit learners with grade 11 certificates. I therefore wish to ask the Honourable Minister the following. 1. Universities in Namibia, and even our own University of Namibia, and abroad, do not recognize the new grade 11 qualifications for admission. What is the stance of the Ministry on this? Secondly, does the Ministry deem it prudent to increase the accessibility and affordability of technical and vocational education and training TVET programs to accommodate learners with grade 11 certificates? Thirdly, have employers been consulted to ensure that learners with grade 11 qualifications have relevant skills for the workforce? Fourthly, has the Ministry done monitoring and evaluation practices on the new curriculum? If yes, what are the outcomes? And further share with us what interventions your Ministry will implement. Fifthly, given the high failure rate and other challenges faced by both learners and teachers, is the Ministry considering reviewing the curriculum to make it more effective or reverting back to the old curriculum. Sixthly, many parents are clueless about possible career paths for grade 11 learners. What efforts are being made to educate parents and learners about the new curriculum and career pathways? Seventhly, is the government open to reviewing and possibly changing the curriculum if it proves to be problematic? And lastly, what feedback has the ministry received from parents, learners and teachers about the curriculum change, and what was the response from the ministry? I so submit, Honourable Speaker, a second question or set of questions. I hereby give notice that on Thursday, 27 February, I shall ask the Minister of Education, Arts and Culture, Honourable Anna Esther Pundoka, the following. The late Nelson Mandela once said, quote unquote, education is the greatest equalizer. Meaning, if it has the power to break down social and economic barriers, giving everyone a fair chance at a better future. However, this is least expected from the Namibian education system. Honourable members, well-resourced schools play an important role in improving the quality of education and student performance. In Namibia, educational disparities still exist between urban and rural areas 34 years after independence. It is important to ensure that schools have adequate resources to achieve equity and excellence in education. I therefore wish to ask the Honourable Minister the following. What is the government doing to improve school infrastructure, especially in the rural areas? How many schools in Namibia still lack basic facilities such as classrooms, toilets, electricity, and what plans are in place to address these issues? What can learners in under-resourced schools expect to have access, or when, to modern facilities like science labs, libraries, and computer labs? With the rise of digital education, how does the government plan to equip underprivileged schools with computers, internet access, and e-learning tools? And lastly, how does the ministry ensure that funds allocated for school improvements are used effectively and reach the intended schools? I so submit, Honourable.
Thank you. Okay, next, motions, notice of motions, messages from that estate. Oh yes, Honourable Minister of Education.
Honourable Speaker, I give notice that on Tuesday, the 25th February 2025, I shall move that this Assembly discuss and adopt the school grant policy, whose primary objectives are: 1, to ensure an equitable funding mechanism that addresses the basic education curriculum attainment, the individual learner, and the school's needs. 2, to enhance efficient and effective use of financial resources at school level. 3, to improve timelines of fund disbursement to schools. And last, to ensure transparency and accountability in the utilization of the education grant. I so move, Honourable Speaker.
Thank you. Let's move on. Messages from the head of state, ministerial statements, if any. So we are done. The secretary will read the first order of the day.
Resumption of committee stage, roads bill.
Thank you. Does Honorable Deputy Prime Minister and Minister of Works and Transport move that the Assembly now goes into committee?
I so move, Comrade Speaker.
Thank you. It is moved that I leave the chair. Any objection? Who seconds? Thank you. It's agreed to, and I call on the Deputy Chair of the Whole House Committee to take the chair.
The whole House Committee is called to order. The whole House Committee has to consider the roads bill. Honorable members, I would like to inform the House that when progress was reported on Tuesday, 11th February 2025, the arrangements of sections clauses 1, 58, clauses 60 up to 69, schedule 1 and 2, and the title were put and agreed to, while clause 59 stood over to be amended. I now put clause 59. Any discussion? Honorable Deputy Prime Minister and Minister of Works and Transport.
Thank you very much, Comrade Deputy Chairperson of the Whole House Committee. You accurately articulated what transpired after consultations, first here with our legal minds, Minister of Justice, former Minister of Justice, and eventually through them, the legal drafters, and ultimately the Attorney General. I wish now to move the amendments as follows. That in the bill, substitute subclause 6 of clause 59 for the following clause. 3 members of the appeal board constitute a quorum of the appeal board. In the bill, insert after subclause number 6 of clause 59 of the following subclauses and renumber them accordingly. 7. A decision of 3 members of the appeal board is not binding unless it is ratified by a majority of all the members of the appeal board. 8. The chairperson or a member of the appeal board presiding at a hearing has, in the event of an equality of votes, a casting vote in addition to his or her deliberating vote. 3. In the bill, substitute subclause number 14 of clause 59 for the following subclause. If all 5 members of the appeal board sit to hear an appeal, the decision of the majority of all the 5 members constitute the decision of the appeal board. I so move the amendments accordingly, certified by the Attorney General.
Thank you, Honorable Deputy Prime Minister and Minister of Works and Transport. Can you submit the amendments? Any further discussion on the amendment on clause 59?
Aye.
Any objections?
No.
Agreed to. I shall report the bill with amendments. Speaker, the committee has gone through the bill, bid 2025, as set forth in the accompanying copy and agreed to it with amendments.
Thank you. Thank you. Thank you very much. Does the Honorable Deputy Prime Minister and Minister of Works and Transport move that the bill be now read a third time? Thank you very much. Any objection? Who seconds? Agree to? Good. Any further discussion? In the absence of such, does the Honorable Deputy Prime Minister and Minister of Works and Transport wish to reply?
Thank you, Comrade Speaker. Simply to say that Article 63, subclause number 1 of the Constitution requires us here in the National Assembly, which is the principal legislative authority of Namibia, to make laws, good laws. I would like to thank all the members who participated and all of us who have supported this amendment. Of course, laws are not static. Laws are dynamic. We also have the power during implementation, if it is so warranted, to come back and make the necessary amendments to our laws. But for now, thank you very much. We have done a good job. Thank you.
Thank you. I now put the question that the bill be read a third time. Any objection? Agree to? Thank you. The Secretary will now read the bill a third time. Roads Bill. Thank you very much. Let's move on. The first notice of a motion is the one of the Honourable Minister of Finance and Public Enterprises. Does the Honourable Minister move the motion?
I so move, Honourable Speaker.
Thank you. Who seconds the motion? Thank you. Any objection? Agree to? Good. Honourable Minister of Finance and Public Enterprises, you have the floor.
Thank you very much, Honourable Speakers, Honourable Members. I rise to submit a request to amend the rules of our pension fund, all of us who are here, the members of Parliament and other office bearers pension fund. As we all know that in terms of Rule 55 of the rules of the pension fund, read together with the relevant provisions of the Act which is Members of Parliament and Other Office Bearers Pension Fund Act of 1999, any amendment to the rules of the pension fund must be tabled and approved by the National Assembly. So any amendment to the rules must be approved by this August House. That's why we are bringing these amendments to you. So we are proposing few amendments, and most of them are very technical in nature. So I'm going to explain what's the rationale behind the amendment. The key one is really, which is going to affect most of us, especially for the younger parliamentarians, is the retirement age. So that, I think that's probably the most substantive one, but it's also not very substantive because the rule was already changed. It's just a definition that needs to change. Then I will explain in a short while. So it is on this basis that I submit the following: amend the reserve account by adding Rule 114, and the details are actually provided to you. Rule 114.5, 14.6, and 14.7 to Rule 14 to allow the creation of a data reserve account, processing error reserve account, and risk reserve account respectively, as recommended by the actuary of the fund. Now, the main reason behind all this account is really that when you are managing a pension scheme or a pension fund, so you make pension payouts to members, but sometimes you may make mistakes because the information that you have may not be correct, and therefore you make a provision for that to set aside some savings, so that when you make some mistakes, there are savings that you can go to and make use of that saving to ensure that you pay members what they are entitled to. So it's basically a prudent way of managing a pension fund. So you want to have a reserve account, you want to have a processing error account in case you pay wrongly, you want to have a risk account. So these are basically just savings that you are setting aside so that when there are mistakes, and this is a common practice in all the pension fund schemes, or most of the pension fund schemes, you want to have some savings set aside so that members are not negatively impacted if some mistakes for one reason or another it's made. So that's the first amendment. The second amendment is to replace Rule 8.1, which provides a discretion to the Board of Trustees to determine the number of meetings per year, which, with a new rule, Rule 8.1, which will allow for a minimum number of 4 trustee meetings to be held in the calendar year,
in line with good governance principles. In other words, all what we are saying here is that, yes, the pension fund has got a board. They are called trustees, and I'm one of them. And as per good governance practices, the board must at least meet 4 times a year, because they need to manage the business of the fund together with the management. So you don't want to leave it arbitrary, that sometimes they only meet twice, sometimes they don't even meet at all. So you want to have a threshold of meetings. And of course, if the board or trustees believe that there are urgent matters and they need to meet more often than 4 times a year, that flexibility is also there, but you want to have a threshold. So at the moment, there is no threshold prescribed in the rule. That's why we are proposing a threshold to be provided for in the rule. So that's the second amendment that we are making. The third amendment is to add a new provision to the Rule 17A that will require pensioners to provide proof of existence. And I think this is common cause. Yeah? Such as the annual certificate of existence to confirm whether the pensioner is still alive and to ensure that the payment of the pension is made to the correct pensioner. So we don't want ghost pensioners in the scheme. So we need to make sure that the people who are benefiting from the pension, because when you go on retirement, you are going to receive monthly pensions, and this monthly pension must go to the right members. Yeah, so no ghost pensioners. So that's really the rationale behind the amendment. The fourth amendment is to amend the fund rules provision establishing a retirement date. So here there was a bit of a confusion. So the rule was already amended in 2015, which basically says retirement age, a member can retire at any as soon as a member leaves the fund. But when you look at the definition of what is retirement, the definition was saying you must be 55 or above. So that's what we are changing. So you don't need to be 55. As long as you complete your 5-year cycle as a member, you leave the fund, you are still entitled to your pension. Essentially, that's the new rule. Yeah. So, and linked to that is also retirement through ill health. That's also refined to ensure that it's aligned to common practice. That if a member has to leave the fund because of ill health, that the member is also entitled to have pension. You don't have to be 55 and above. So essentially, these are the amendments that I'm tabling, Honourable Speaker. It's for the good management of the fund, and it's also for the benefit of the members. I so submit.
Thank you very much. Thank you particularly for that clarity. Honourable Dianda.
Thank you very much, Honourable Speaker. Honourable Speaker, I want to thank the Honourable Minister for this amendment, because when I bring up this issue here in Parliament, people were telling me, now you are old, you are what? But I didn't do it for me, I did it for those ones who didn't understand their time, what it is all about. So next time, before insulting people, just read what is. Just go and read the rules and things. Yes, I came here with that thing and I said, when you're younger than 55 years old, you are not allowed to get a pension, and they did not believe me. Yes, now, go. You are sleeping, you don't even give us feedback that you're a trustee member. Honourable, I want to know these boards of trustees like Honourable Katamela, who's representing us, who never give us feedback. Can you not say something about them? They cannot sit there warming up seats. Don't come back to us and tell us anything. But they are board trustees, board members. Just warming up the seats. That is my first question. Yes? Can we bring it in here so that those who represent us must also give us feedback and not say, you are not there representing your family. Yes. My first question, that one is my first question. It must be in the rules feedback from them. So then, this reserve account, thank you so much. You know, it happens with me. Wrong calculations. As the staff here, for 2 years I was fighting with GIPF because I was a member of parliament. Parliament did not deduct a monthly pension from me while I was sitting here like a ghost. Yes, luckily I pick it up, and I was told now I must pay back those money because they did not deduct it, and it was a lot of stories. And I almost lost a lot of money, Honorable Speaker, because others were benefiting, but I could not benefit because I was a ghost that time. And they have to wait and bring in money later because it was not a 20 Namibian dollar. It was a lot of money that I almost lost because of this. So thank you for that correction. I think they learned from my mistake because I pressurized them. I say I want my money to be there on my pension benefits. Then the second one is on the rules that is existence. I agree with it. The fund rules, Honorable. Say for instance, according to the rules, it does not make provision for it. It only makes provisions that when you are 5 years in Parliament, this is what you will get. This is what they say you will get. But if you are, for people who are just 1 year in Parliament, that is a challenge. Because you can only get what you have contributed. Nothing more, nothing less. So I just want you to explain this. Because people think because I was in Parliament, I must get what the others are getting for 5 years. This is not what the rules say. The rules say only the ones from 5 years is entitled to this. You are only entitled to what you have contributed towards the fund. So I cannot say that, Honorable, even you people don't understand this. It's not only my members, you also don't understand these things. So I cannot make a comparison to say that I'm this Parliament I came into this Parliament and I need to have the same benefit as Honorable Ina Ngari, who sit here for a longer period. You cannot. But Honorable, I also want you to look, Honorable Shimi, they are disturbing you, I want you to listen. If you are spending 5 years in Parliament, you are entitled to 60% of your basic income. This is what the rule says. 40. Where?
No. Can I?
40%.
Please.
Only entitled.
Honourable member, please wait. Wait a minute. You know, honestly speaking, when a member is on the floor, allow that member to have his say or his say. Then you want to take the floor, come in. But this interjection, it's very disruptive. We are at the end of our departure, having served so many years. We should be much more experienced in dealing with these sort of issues. It is the kindergarten when people do those things. Not here, please. Please continue.
Thank you for protecting me, Honourable Speaker. I wanted to take out the document which was tabled by Honourable Kali in 2015.
No, please, not Honourable Kali. Honourable Straightway.
I can't say that.
No, but then you refer to his. No. It is you don't. No. Honourable. No. The rules are clear. The rules are telling us, all of us, you cannot refer to your colleague and remember by his or her first name. It's never done.
Okay,
please
Honourable
continue. Find another way.
Honourable Slutwine. I can't say the word, that's why I say Honourable Slutwine.
Please, let's get on.
So I just want to say Honourable Slutwine in May 2015 tabled the members of Parliament, the new rules that came into action. I had it here, but I can't look for it now. So, Honorable, I was just wondering. One term, it is almost 13,000. Two terms, it is like 26,000. But if you go to your third term, which the highest is 70,000, and you are backbencher, you are not really benefiting that much. Just look at that 70, not 70, third term, yes, is 70%. If you make that comparison between somebody who only sits for one term in Parliament and the person who are sitting for longer, 3 terms and longer, the comparison is like a few thousand, 3,000 or 4,000. Yeah. So it is, yes, it's true, Honorable, just go at your basic salary. And then you're asking yourself, it's better to exit at 2 terms. Because when you're sitting longer here, you are not benefiting any much. So this is what I want to say, Honorable Minister of Finance. If you look into these calculations, I have it here, I will send it now to you. I must just refer. This is all that I want to say,
Okay, thank you very much. Honorable Dr. Albert Kawana.
Thank you very much, Honorable Speaker. Let me take this opportunity to thank most sincerely my nephew, the Honorable Minister of Finance and Public Enterprises. Como Speaker, I'm very, very happy today regarding this amendment, because as the Honorable Minister said, there was so much discrimination in terms of age, to the point that our young people were losing interest in politics, which is dangerous for our democracy. In a mature democracy such as ours, there must be that smooth transition, succession. The Tanganyika group, I'm looking at one in this house, they are leaving us. Obviously, some of us, the group of Nampundwe,
yes,
are also following the Tanganyika group. But we need also to leave behind our young people who have been groomed, who have gained experience from the seniors. That's how democracy can flourish. Because some of us were so worried to the extent that if young people lost interest in politics, especially wishing to become members of parliament, we could end up with honorable members, maybe 100% using walking sticks, coming to this chamber because there's no that smooth transition. Now, Honorable Speaker, once again, really I just wanted to point out this. And in fact, I was even wondering, as a former Attorney General, whether these differentiations were constitutional. So I think now really, I know one case of regional councils that time. The member serves for 2 terms and the monthly pension is less than 2,000 per month. How do you survive on that? Really now, at least, and I hope our public out there will understand that this is good for democracy, it's good for our youth, and I wholeheartedly support the amendment. I thank you.
Thank you very much. They say better late than never. Honorable Katamero, you are not going anywhere. You have the floor.
Yeah, no, thank you, Honorable Speaker, honorable members. Just maybe as a clarity, to say that the rule of 55 was done away through the chairmanship of Honorable Sletwine. That's why Honorable Muharuka, just to mention a few, Nico Mugenga, Raphael Mukaleng, Honorable Kavura, in as much as they were not 55, retired in 2020, others, and are still benefiting, doing away with the 55 rule. Did not apply. Not a new thing. But the anomaly that we need to address maybe is, and I, just for illustration, allow me a little bit of latitude, just to explain by mentioning members. I think my senior Honorable Kawana always used to say, you cannot mention people who are not members of this house. But I will mention people who are members of this house. Honorable Mike Venani Inyangu and Honorable Shamaine joined together. Honorable Shamaine. Oh, Shirari. Yeah, sorry. Shirari. Honorable Shirare does not qualify, but Honorable Venani do qualify. That's the anomaly that we need to address and to filter into why is it. But as I said, the 55 rule was already done away with, and notwithstanding the definition that was there are classical examples of people that has retired and that continued to get their benefit. Honorable Muharuka was just the latest, but all others that I mentioned exited in 2020 and continued to benefit. Even myself, I resigned in 2019 prior to coming to here. I was regarded as a pensioner at 65 or whatever percentage. Now, in terms of percentage, what the rules say is one term is 40%. The second term that ends at 10 is 65%, 10 years. And the other addition is 11 years. The thought of 11 years that time, the people who joined the regional council elections in 2010 are the first group of intake that served 5 years. All others prior to 2010 was 6 years. On the way to the election, that's where the act was changed to bring the term in synergy of the regional and local with 1 year. And that is the reason why you get now that 5 years, the first 6 years plus the new 5 years of that started in 2010 together will give you 11. So I just want to give a historical understanding of the 11 vis-a-vis the 10. It's because the first councillors, yes, Honorable Demula are the councillors before us, and their term was 6 years. So when we came on board in 2010, our term was then shortened. We started with the 2010 group is the first group that started with the 5-year term, and the others started at a 6-year term. So, and that is the demarcation. Now, it's also important to note that our fund is a defined benefit fund. It's not defined contribution. In simple terms, what it says is, when in terms of calculating your pensionable salary, the fund look at your last pensionable salary. But a defined contribution arrangement is far different than a defined benefit. Because ours is a defined, what you will get is already set and filtered into in terms of a formula. You will get 65% of your pensionable salary. Now, whether you become a minister and a speaker and a deputy, it does not matter. What it looks at that particular moment is your last pensionable salary. So me and Honorable Mondestus could start the same. We started together in 2010. He got fortunate to be elevated 2 months before exit as a deputy minister. His salary and his pension is going to be different than mine, even though we served the entire 9 years and 10 months together as backbenchers. But because his salary prior to exit, his last pensionable salary, will be much higher than mine, therefore his pension, which is a percentage of his last pensionable salary, will be much higher than mine, regardless of the time that we spend together in the fund. So I think I thought I just needed to respond to my auntie, to honorable, just to clarify. Sorry. To honorable
Gender. Yeah.
Sorry.
Thank you.
Okay.
Thank you very much. Honorable Split by.
Thank you, Honourable Speaker. I also rise to support the amendments of the rule. They are coming a long way, and I have been a pensioner or a trustee, for some time. Now, Honourable Diana, my name is Schlettwein, not Strootwein, and I don't like if people play games with names.
No, I honestly, I don't want to dwell on this one. I think it is much more dignified for us to make an effort in pronouncing other people's names, because that is you. So it is polite to try and get it right. We are not imposing it, but it's important for your own self-respect. Please, Honourable Member, continue. Okay.
Thank you, Honourable Speaker, that you have understood me. I do believe that is good manners. Honourable Speaker, the Political Office Bearers Pension Fund started off as a contribution-defined fund, which means you only get a pension to the amount that the fund grew. Now, the reason for adding a progressive rate of assured pension fund was that at that point in time we were facing a financial crisis. Pension funds didn't grow, they actually made losses, and that meant that people that went on pension then had really small benefits. Now, we went then and said, well, we cannot allow that a parliamentarian goes out without a decent pension, and we added to the contribution defined benefit that you get a obligation by the employer to make sure that whatever happens, if you served 5 or 6 or 7 or up to the maximum of 11 years, then you will get a staggered, a progressive rate of pension to add it to your pension fund. So we are not a defined benefit fund per se. We are a hybrid. Your pension is calculated out of growth and a contribution by the employer, which ends at the maximum of 75 or 70% of your pensionable salary, and it starts with 40% of your pensionable salary. So that is the reason for the rates that are differentiating, whether you are there for 5 years, for 6 years, for 7 years, or for 11 years. I want to thank Honourable Catabello, who has explained that the 55-year rule was addressed at that point in time, but we didn't go to the definition. I think it is just clearing up a possible ambiguity that could result in disputes, but there are no disputes, and I'm very happy that that was picked up and that is now cleared. So I support the rule amendments. It's a good thing that we do that.
Thank you very much. Next, the Honourable Hengari.
Yes, thank you very much, Honourable Speaker. I want to support and this particular move by the Minister of Finance as a young person that holds full understanding of the implications that some of these provisions held, especially for those under the age of 55, but 55, sorry. But I think there's an aspect that has not been addressed by the proposed amendments, and I want to support the Honourable Catamelo. I think there's a question that this proposed amendments has not answered. And it's a question of, if, for instance, in an instance where somebody was supposed to be or is a member of parliament and for whatever reason, right, didn't make it to the House, and there was some other elements and factors that particularly influenced their entrance into parliament, and not to say that the individual was not a member of this House in the first instance, what happens? And I think it goes to the question of Honorable Katamelo, because members in this House unfortunately join parliament at any point of that period, of the 5-year period, so they can come in at 2 years or 3 years of that one particular term. So I really want to understand that particular aspect, and when the minister will introduce an amendment that speaks directly to a situation where a member comes 2 years into the term or through a court order or whatever. I think it's ambiguous at this point, and I think it makes most of us very uncertain, and it shouldn't be the case. My second question has to do with having the Board of Trustees and members of this House being part of that particular structure. In my thinking, or at least in my very pious understanding, I would think that members of this House who also serve as part of the Board of Trustees would establish some sort of structure that would ensure that members of this House are informed of circumstances that change around the fund, around their benefits, and just have some sort of formal communication, because there is no way that we can sit here, Honorable Speaker, for 2 hours talking about benefits. There are other platforms, and I believe there's a committee on privileges that also deals with members' benefits and privileges. I would have thought that because we have members who serve as part of the Board of Trustees, that there would be some platform organized by those members who are part of the Board of Trustees and the members of this House, so that we don't spend so much time here. And also, I think there's just been a lot of misunderstanding and a lot of not knowing, because a lot of information is not shared with the ordinary members. It's just like this. Any person, right, whether you are a private citizen or you're not, or you are a public servant, you would want to know and be ascertained of what is due to you because of the service that you have given, right? And I think the Board of Trustees really need to get together, form some structure, so that they can just inform members, so that every year, as you are inducting members to this House, they have a full understanding of what is what and where to go when they need this information. Thank you, Honorable Speaker.
Thank you very much. Thank you very much. In the absence of any further discussion, does the Honorable Minister of Finance and Public Enterprises wish to reply?
Thank you, Honorable Speaker. And let me also thank the honorable members of Parliament who have taken the floor to support the amendment to the rules, and also those who have offered clarifications, Honorable Katamelo, Honorable Yinda, and Honorable Schletman. I believe they have already done my job, and therefore I don't have to say much on it. So I want to thank them for that. And I believe it's now clear that the problem was not the rule. The rule, as I said already in my statement, was already amended in 2015. The problem was with the definition, so the definition was not aligned to the rule, and that's what we're just trying to clean up, as Honorable Schletman has said, and Honorable Katamelo. And therefore, Honorable Speaker, I just want to put it on the record. It's not because there are some people who think that I'm less than 55. I'm more than 55. So therefore, this rule is not going to benefit me. This rule change is not going to benefit. So it's not for me, Honorable Speaker. I think it's important to be for that to be clear. Yeah. I think there was a question from Honorable Genda there. Now, if you have not been a member for 5 years, how are your benefits going to be calculated? And I would want to encourage those members to actually seek appointment with with the management of the fund, and I can make that available. I mean, I can talk to them. I can arrange that so that they can come and talk to the members, because I think this is very important information. But suffice to say, so the retirement period is, or the membership is for 5 years. Now, if it's 5 years, then you get part of the guaranteed benefit, the 40% that we have talked about, if you have only served for one term. And it goes like that, depending on the number of years. Now, if you were only a member for a few years, so what you get as part of your pension is your own contribution and the employer's contribution. So that's what you're going to get. So the guaranteed part is not there, unless you are above 55. Yeah, unless you are above 55. So if you are above 55, the rule says, then you can at least get 40%. Yeah. So that's the explanation. And again, these are.
I really.
And the second question.
Can we
the second
listen
question,
quietly?
Speaker,
Yeah.
Second question, Honourable Speaker, I think is an issue is when does somebody become a member of Parliament? And I don't think the trustees are the competent authority to talk about when does somebody become a member of Parliament. If you were not a member of Parliament before and you joined 2 years after that, I think that should be, it's probably Parliament that has to determine that this person is a member and therefore is a member from this date. So the pension funds only takes from Parliament as to when the person became a member. So I don't think you start with a rule or with a fund. You actually start with Parliament. So I think that's the starting point. Once we agree on the date of joining Parliament, then the fund will also then take it from there.
The other issue, Honourable Minister, I think we also need to have a sort of inbuilt system of briefing members so that they are educated, properly informed, so that they can plan knowing exactly what is to be expected. I just thought something like that would help, particularly as we are going to have a new parliament now. So your idea of arranging for something like that should become part of the system from time to time. Yeah.
We will take it to the management of the fund to have regular sessions with members of Parliament, with members of the fund, so that they have access to this information.
Thank you. Thank you very much. Honourable Hengari, I see your light is on, and I'm just beginning to wonder. The Honourable Minister responded by replying. So I don't know whether, did I get it wrong? No, I'm saying both the Honourable Katamero and Hengari, you attempted to come back at the point where the Minister is responding to queries as you have raised. Am I wrong? I'm wrong. How am I wrong? Are you asking for the floor? Are you asking for the floor? I'm saying, I'm assuming that you are asking for the floor. No, but no. I think both of you are out of order. Can I hear you?
Very much. The Honourable Shimi brought an amendment to the House.
Yeah.
The members queried, responded.
Yes.
But the rules also allow for follow-up questions under the rule that speaks to the Speaker's discretion. So I'm asking for the Speaker to use his discretion in this particular case. Honourable Speaker, because the rules allow the Speaker just...
I will not do that. I will
Emma,
not
you're
do
also
that.
affected. Just
Forget about
it.
it.
Is well. It's fine.
No. What are you asking for the floor? Huh? Do you know where we are now? No. Sorry. No. Honorable members, No. We, no. I'm not going to give you the floor. I'm not giving the floor to anybody now. No, order, please. I put the question that the motion be adopted. Is there any objection? Okay. Yeah. Okay. We are dividing the house. It is simple as that. I'm at this point. Is there an objection? Okay, we take note of your objection. Yeah, we take note of your objection. Yeah. Then I'm taking note. I'm going to put the matter to a vote right away. Yes. Oh yes. You cannot just say. You cannot say no. I'm not going to permit. I'm not going to allow further discussion. The honorable no. I'm not entertaining your point of order. I will not entertain. No. Okay. Honorable members, I'm asking you a question. If there's an objection, I'm obliged to divide the house on this issue. Yes. Yeah. Order. You are not going anywhere with this one. I'm not going to take. No. You are reversing. No. I'm not going to do that. No. Okay. I'm going to. Order. We are going for tea break. If you got issued to consult the minister available, you may consult him. Tea time. And while we are checking the number, we are of the view that this is subject matter we need to have regular meeting in terms of looking at the conditions for members of parliament in terms of the pension and other rights that members are entitled to. I think we have to organize more occasional activities where people will have opportunity to raise issues and to be properly briefed on the conditions of service. The Honorable Minister of Finance undertook the responsibility to make sure that is done. But for now, we are not able to handle this subject because we are short of 7 members. Huh? Yes? Yes? Yeah.
Okay.
Yeah.
No, I wanted to lean on the wisdom that we had last week.
Sorry.
I wanted to lean, to borrow, to circumvent on the wisdom that prevailed last week during the roads bill. And maybe from what has transpired, maybe to get this agenda item packed until those consultations are held, because it will be in the best interest of enlightenment and taking a decision from a very much informed viewpoint.
Honorable Katamelo, no.
Oh.
No, not at all.
Okay.
We have gone through this item. The Honorable Minister replied, and we are at the point of putting the matter to the House. Now, the consultation into whatever else is needed to strengthen the amendment or certain aspect of this can still be undertaken. But for now, given the time that we are exiting, we want to make sure that nothing is held back. Let's take on the amendment as presented by the Minister. There is a clear understanding that this is something that we can carry on. And if into the future you want to continue to have this discussion, you may be able to do that. But I'm not going to put the question because we don't have the number. Huh? We do, yeah. Yes, we do, Honourable Member, you are right. I put the question that the motion be adopted. Are there any objections? Okay. Objections? Yes, Honourable Twaya. Honourable Twaya.
Honourable Speaker, I have asked for the floor for point of order.
Can we listen to each other?
Honourable Speaker, honourable members, my point of order is I do not think that it is correct for this House to move on this path by splitting unnecessarily. The amendment, as it was presented, the members are not fully clear on those amendments. Honourable Speaker, Honourable Katamelo shared with us and said, let us borrow the wisdom of last week during the roads bill. What that really means is, even if you have gone through all the processes, and at the end you see that the House is very uncertain and shaky, you cannot, and it is not correct, to bulldoze because you have finished that. The issue is in terms of the wisdom. it is not for the presiding officer now really to stop that process. The mover would have seen that the mood in the house is not fine. I would really want to ask the mover to help the presiding officer to ask and say, all right, I understand. It will not go away to say, let us hold, but it should come from the mover and not so much from the presiding officer.
I got the gist of what
Thank you very much, Honorable
Now,
Speaker.
for your information, the point of reference you are referring to, the Honorable Minister of Finance, the mover of the motion, is the one who replied and allowed me to proceed to put the question. So to how many ministers who bring motions here, to whom do I need to respond to other than the mover of the motion? So I consider myself to be actually right in moving the way I proposed to put the question, because the Honorable Minister actually sanctioned that. He responded and he said, I should put the motion to the House. It's on that basis that I presented the motion. So if the House is not united on the subject matter, they should alert the presiding officer. Nobody has informed me that there was a contrary view on the subject, other than one or two members who were raising hands after the Honorable Minister had responded, which is actually, in terms of our rules, I should proceed on that basis, if need be, put the matter to the House to vote. So am I wrong? In what sense am I wrong? So I repeat again, Honorable Minister of Finance, you are ready for the House to proceed. This is my understanding. On that basis, I put the question.
We have 3 members less. They went out.
Okay. Now, again, those who don't want the motion to succeed are no longer in the chamber in order to block. Are they in the restaurant? Now, this is not the work of the presiding officer. This is the work of the whips, to make sure that members are disciplined enough to be in the House when they are required to be in the House. Yes, Honourable Member. Yes, please.
Honourable Speaker, I think the problem here is just a slight misunderstanding, because the 3 honourable members who walked out, they are not in agreement with the rules. So they wanted just to be explained thoroughly, to understand, so that perhaps they can agree with the House.
But the minister took them through by explaining, everybody's hearing. If there are other things that are beyond their comprehension, then obviously that cannot be handled in this particular session. And that should never be used as an excuse for allowing the House not to proceed. And so I'm in your hands. So in the absence of a sufficient member in the House, I'll move to the next item. Yeah. The second notice for motion is the one of the Deputy Prime Minister, Minister of Works and Transport. Does the Honourable Minister moved? The motion? Thank you. Thank you very much. Who seconds the motion? Thank you. Any objection? None. Agreed to. Honourable Deputy Prime Minister, Minister of Transport, you have the floor.
Thank you very much, Honourable Speaker, for giving me the floor to motivate and to request this Honorable House to consider the ratification of the Maritime Labour Convention of 2006 as amended. By way of introduction, let me state that Namibia is a coastal state. We have a long coast, starting up there near the border with Angola, down to the south in South Africa. And therefore, what is happening in our sea is of paramount importance, both in terms of resources, which is managed by the Ministry of Fisheries and Marine Resources, but also with regard to maritime transport and regulations and all that. It is with a great pride and deep sense of responsibility that I rise today to table the Maritime Labour Convention before this esteemed House. The Maritime Labour Convention of 2006, commonly abbreviated as MLC 2006, as amended in 2016, is an important international labour convention adopted by the International Labour Organization, ILO. This convention provides international standards for a fair and equitable merchant shipping to both the seafarers who work in sometimes lonely, massive border of waters on the open seas, to ensure trade takes place between nations and scrupulous ship owners who compete with substandard ships, which are a safety risk to seafarers and also pollution to the marine environment. Widely known as the Seafarers' Bill of Rights, the Maritime Labour Convention that I'm requesting the Honourable House to consider and ratify of 2006 was negotiated and finally adopted by governments, by employers, and by workers' representatives at a special International Labour Organization International Labour Conference that was held in the month of February of the year 2006. It came into force in 2013 for those countries which have ratified the convention. Honorable Speaker, honorable members, this convention is a comprehensive international legal instrument and sets out in one place the seafarers' rights to decent working conditions. It covers almost every aspect of their work and life on board of vessels, ships. Some of the areas that are covered here is the minimum age of those seafarers who must do this work on the seas, seafarers' employment agreements, hours of work or rest, payment of wages, paid annual leave, repatriation at the end of the contract, on-board medical care. the use of licensed private recruitment and placement services, the issues of accommodation, the issues of food and catering on board of these vessels, the issues of health and safety protection, and the issues of accident prevention. This convention, therefore, brings together in one place international minimum standards that ensure decent work for the estimated more than 1.5 million seafarers around the world whose work is essential to international trade as well as to an increasingly important form of tourism and recreational activity. The convention ensures that every seafarer has the right to, for example, a safe and secure workplace that complies with safety standards, fair terms of employment, decent working and living conditions on board of ships, health protection, medical care, welfare measures, and other forms of social protection. As a nation that depends significantly on maritime trade, the Cabinet of the Republic of Namibia in the year 2019, through decision number 10, which was taken on the 11th of June 2019, directed the Ministry of Works and Transport to expedite the process to ratify this convention. The adoption and ratification of this convention will therefore reflect Namibia's recognition as a country, the critical role seafarers play, and the need to ensure that such seafarers enjoy, like any other employee on land, us here too, a decent working environment, while of course ensuring that ship owners who comply with the law are protected against ship owners with substandard vessels or ships. And these substandard vessels or ships can compromise the safety of employees and the maritime environment. Honorable members, Honorable Speaker, by ratifying the convention, we as a nation, as a government, are demonstrating our commitment to the safety, welfare, and dignity of the men and women who work at sea. This is not only a step toward aligning with international best practices, but also a firm declaration of our intent to strengthen our maritime framework, promote fair competition, and attract investment in our rich maritime sector. I wish to emphasize that the convention is also key to enhancing our country's reputation as a responsible member of the global maritime community. It does signal to the world that we are serious about upholding the highest standards of labor rights, health and safety within the maritime sector. The convention applies to all ships of 500 gross tonnage or more, whether publicly or privately owned, which are ordinarily engaged in commercial activities, except ships engaged in fishing or in similar pursuits, ships of traditional build such as dehoes and junks, and warships or naval auxiliaries. The convention contains important compliance and enforcement components based on a flag state ship inspection, certification system, and port state control. In other words, upon ratification, all convention ships calling our ports will be required to carry certificates of compliance with the Convention of 2006. Therefore, substandard vessels with poor seafarers' employment records or which pose a threat to our maritime or marine environment will not be permitted in our ports. Honourable Speaker, lastly, the tabling of this convention therefore marks a significant milestone in our journey towards a stronger, safer, and more equitable maritime sector. I'm confident that with your collective support, we can make this vision a reality, and therefore I would like us now, when the time comes, through you, Honourable Speaker, convention is a thick document. Let us study it, dissect it, and discuss it, and eventually, as per the relevant provisions of the Constitution, for us to ratify this convention so that it becomes part and parcel also of our national laws. I so move.
Thank you. Any further discussion? The floor is open. Am I to take it that members have exhausted the document, and in the absence of further discussion, does the Honourable Deputy Prime Minister, Minister of Works and Transport wish to reply? Thank you very much. Thank you very much. Now, I'm checking with the front desk in terms of the number before I put the question. We are almost there. Do we have one in the restaurant or somewhere smoking a pipe? Can you check once again? Maybe you made an error. Just one. Just one. Let me move on to the next item. We'll come back. We'll come back. I'm sure they will come back. The third notice of a motion is the one of the Honourable Deputy Prime Minister, Minister of Works and Transport. Does the Honourable Deputy Prime Minister and Minister of Works and Transport move the motion? Thank you. Who seconds the motion? Thank you. Any objection? Then being none agreed to, Honorable Deputy Prime Minister, you have the floor.
Thank you very much, Honorable Speaker, for giving me the floor, this time around to motivate the African Maritime Transport Charter for consideration by this Honorable House and for eventual ratification. Recognizing the critical importance of maritime transport for the development of the African continent, the Organization of African Unity, OAU, adopted the African Maritime Transport Charter in July of 1993 as an instrument of cooperation amongst African nations that seek to address virtually every major issue that Africa is confronted within the area of maritime transport, such as poor implementation and enforcement of maritime safety and security, and marine environmental standards, lack of cooperation in maritime administration and port operations, lack of cooperation in maritime and inland waterways, lack of cooperation between landlocked states. Many countries now prefer land-linked instead of landlocked, and transit states, lack of cooperation in infrastructure development, shipbuilding and repairs, and lack of African merchant fleets. In this regard, Namibia signed the African Maritime Transport Charter in the month of July 1999, but without ratifying the Charter to date. However, conscious of the interdependence between economic development and sustainable protection of the marine environment, the African Union, the successor to the Organization of African Unity, revised the Charter to include provisions for the protection of the marine environment and maritime security. The revised African Maritime Transport Charter, in short called the Revised Charter, was adopted by the Assembly of Heads of States and Governments of the African Union in July 2010. Accordingly, Namibia signed the revised charter on the 8th of March 2013, pursuant to Cabinet Decision number 14, which was taken on the 21st of August, the year 2012. Again, that Cabinet resolution directed the Minister of Works and Transport, in coordination with the Minister of Fisheries and Marine Resources, to consider the signing and ratification of the revised charter. Remember, the decision of Cabinet was taken in 2012. The revised charter falls within the scope of international law encompassing maritime transport and related activities in the coastal, inland waterways, territorial seas, including exclusive economic zones of state parties, as well as related activities in land-linked state parties. The strategic focus of this revised charter is on strengthening cooperation among African countries in the maritime transport sector, and its main objectives are, amongst others, 1. Declare, articulate, and implement harmonized maritime transport policies capable of promoting sustained growth and development of African merchant fleets, and to foster closer cooperation among state parties of the same region and between regions. 2. Facilitate and encourage regular consultations for determining African common positions on issues of international maritime policy, and to define for each given problem concerted solutions. 3. Promote effective implementation of international maritime instruments to which member states are parties. Encourage the establishment and support of maritime and ports administrations. Promote bilateral and multilateral cooperation among the maritime administrations of state parties and their respective operational organizations in the field of maritime and inland waterways, transport and port activities. And lastly, to develop and promote mutual assistance and cooperation among state parties in the overall management and operation of maritime administrations and other maritime entities established in terms of this charter. The revised charter is implemented through, amongst others, by the 2050 African Union Africa Integrated Maritime Strategies, aims of 2050, which is an overarching African-driven long-term vision to address Africa's maritime challenges and opportunities with a clear focus on wealth creation for the sustainable governance of Africa's maritime domain. The purpose and the objectives of the revised charter resonate with the maritime interests of Namibia in key areas such as promotion of national and regional transport linkages to encourage intra-Africa trade, to facilitate economic and socio-economic integration in the continent, port reform and efficiency of port services to ensure competitiveness of the African ports, promotion of shipbuilding and repair facilities, and training and capacity building in the maritime sphere. A little bit long speech. With regards to regional initiatives that are aligned to and promote the ideals of the revised charter, the establishment of the Benguela Current Commission, Honorable Claassen, as a multi-sectoral intergovernmental institution established by Angola, Namibia, and South Africa to facilitate integrated ocean and coastal management and sustainable development of the ecosystem of the Benguela large marine ecosystem, is a prominent example in this regard. This initiative is in line with Article number 6 of the revised Charter, honorable members, that are in front of us. Furthermore, at national level, the Charter is in line with government's forward-looking developmental policies, plans and programs, including the national transport policy of the country. These instruments recognize maritime logistics as a key economic priority that should be developed in order to position Namibia as a regional logistic hub with effective and efficient linkages to neighboring land-linked countries or land-locked countries. This initiative, honorable members, is in line with Article number 14 of the revised Charter in front of us. Another national initiative relevant to the Charter is the ongoing transformation of Namibia's maritime administration system, including, and we are so far behind, but we are almost there, including the establishment of the Namibian Maritime Authority in order to achieve greater effectiveness and efficiency in the delivery of maritime regulatory services, and to ensure that Namibia gives full and complete effect to her international and regional maritime obligations. For more information concerning this initiative, consult Article number 7 of the revised charter. Equally, another national initiative that is aligned with the revised charter is the establishment of a national interministerial Blue Economy Committee, which promotes an integrated and coordinated approach to ocean governance in order to unlock the immense potential that the ocean economy presents in addressing socio-economic challenges. The above developments and initiatives make it therefore imperative for Namibia as a maritime nation of note to ratify this revised charter. As I conclude, Honorable Speaker and Honorable Members, failure to ratify the revised charter, I think you will agree with me, will further derail the regional and continental status and reputation of Namibia as an emerging regional maritime logistic hub. And we have a long coast, and we must make use of it. I so move, Commissioner.
Thank you very much. Thank you. Any further discussion on this subject matter? In the absence of further contribution, may I ask the Deputy Prime Minister to reply?
Again, Honorable Speaker, it's a charter, maybe too technical, but we have a real practical situation to address. We are a coastal state, the blue economy, the what, in the Atlantic Ocean. And therefore, we have to get legal instruments in place in order to maximally regulate and manage the resources in the ocean, including the maritime transport itself. So thank you very much for the support. Again, as I said, practice makes perfect. We make laws here and regulations and conventions and treaties because we are a country ruled by laws, and those laws must be applied fairly and justly. So thank you very much.
Thank you very much. I'm still assuming that we are short of one person for me to be able to put the question. Can you double check? Four. So we are completely short. Three people. We are short of 3 people, and let us continue. I don't want to lose more people. Honorable Katemelo is back. Thank you very much. So we are short of one person. Now we are only short of one person. This is no longer a laughing matter. It's a matter that is very important because the more we reduce So, are we almost there? Just one person. And that person, I'm told, is on their phone outside. Okay, I'll move on to the next item while we are waiting for that one more person. In the meantime, we close doors. The fourth notice of a motion is the one of the Honorable Deputy Minister of Home Affairs, Immigration, Safety and Security. Does the Honorable Deputy Minister of Home Affairs, Immigration, Safety and Security move the motion? Thank you. Who seconds the motion? Thank you. Any objection? None? Honorable Deputy Minister, you have the floor.
Thank you, Honorable Speaker, for giving me the floor to motivate the ratification of the draft SADC protocol on the interstate transfer of sentenced offenders. Nelson Mandela once said, and I quote, "It is in your hands to make a better world for all who live in it," unquote. In the spirit of Mandela's vision for a better world, not only for the ordinary citizen, but for those who found themselves on the wrong side of the law and are seeking a second chance in life, and not only second chance in life. Sorry. Yeah, let me start again. In the spirit of Mandela's vision for a better world, not only for the ordinary citizen, but for those who found themselves on the wrong side of the law and are seeking a second chance in life, and not only our citizens, but also those from other countries, I stand before you today for your support in ratifying the draft SADC protocol on the interstate transfer of sentenced offenders. Honorable Speaker, honorable members, Namibia has a law on transfer of offenders, the Transfer of Convicted Offenders Act number 9 of 2005, whereby Section 20 of the Act provides for the minister responsible for correctional facilities to enter into agreements on transfer of convicted offenders, subject to the ratification of such agreement by the National Assembly. The draft SADC protocol on the interstate transfer of sentenced offenders, whose main objective is to allow for the transfer of sentenced offenders to serve their sentences in their home countries, was approved by the SADC Summit at its meeting held in Dar es Salaam, United Republic of Tanzania, in August 2019, and the Republic of Namibia subsequently signed the draft protocol on 18 August 2019. At the Ministerial Committee of the Organ meeting held in July 2024, it was reported by the SADC Secretariat that as of 30th May 2024, 11 member states had signed the protocol on the interstate transfer of sentenced offenders, and only Mauritius ratified the protocol. The Ministerial Committee of the Organ then urged member states that have not yet signed and ratified the protocol on the interstate transfer of sentenced offenders, including Namibia, to do so and report progress at the next meeting in 2025. In compliance with the provision of Section 22 of the Transfer of Convicted Offenders Act 2005, Act number 9 of 2005, I request this August House to ratify the agreement on sentenced persons to give effect to the contents therein. Honorable Speaker, honorable members, as on 17 February 2025, we have 465 foreign inmates incarcerated in our custody. Out of the 465 foreign inmates, 450 are from the SADC region and 15 beyond Africa. At the same time, there are 69 Namibian citizens who are serving sentences in various countries across the SADC region, separated from their families and communities, often far from the support system, and could help in their rehabilitation. The importance of an inmate to serve their sentences close to their families cannot be overemphasized, as it is critical for their rehabilitation and reintegration into the society. Studies have consistently found that inmates who maintain close contacts with their family members while incarcerated have better post-release outcomes and lower reoffending rates. The transfer of foreign convicted persons to serve their sentences in their home countries is an alternative way of implementing a sentence. All things being equal, sentenced persons who serve their sentences in their home countries can be rehabilitated, re-socialized, and reintegrated into the community better than elsewhere. This is a positive reason for transferring sentenced persons to a state with which they have social links to serve their sentences. Imprisonment in a foreign country, away from family and friends, may also be counterproductive, as families are denied the opportunity to provide social support, which improves the likelihood of successful resettlement and reintegration. Honorable Speaker, honorable members, the ratification of this protocol presents an opportunity to address these pressing issues. By ratifying this protocol, we can facilitate the transfer of sentenced offenders back to their home countries, allowing them to serve their sentences close to their families. This is not merely a matter of legal protocol. It is a matter of compassion, rehabilitation, and social reintegration. By allowing foreign inmates to return to their home countries, we can ease the overcrowding in some of our correctional facilities and also saving the government with funds that can be used by these offenders, as well as foster goodwill among our neighboring nations. At the same time, we can ensure that our citizens who find themselves incarcerated abroad have the opportunity to serve their sentences in familiar environments, which can significantly aid in their rehabilitation process. Moreover, this protocol aligns with our commitment to human rights and the dignity of all individuals, regardless of their circumstances. It reflects our understanding that justice does not end with a sentence. It continues with the opportunity for rehabilitation and reintegration into the society. By ratifying this protocol, we take a significant step towards fostering regional cooperation and solidarity in the pursuit of justice. Honorable Speaker, honorable members, the agreement for encouraging the transfer of sentenced persons has a strong basis in international human rights law. Article 10, paragraph 3 of the International Covenant of civil and political rights which Namibia has ratified and acceded to states that the essential aim of a penitentiary system is the reformation and social rehabilitation of offenders. The standard minimum rules of the treatment of prisoners, affectionately known as the Mandela Rules, Nelson Mandela Rules, echo this duty to facilitate the social rehabilitation of offenders. Almost all instruments that regulate international offender transfer specify social rehabilitation as one of the grounds for supporting such transfer. In conclusion, the ratification by this Parliament and the subsequent operationalization of the SADC interstate transfer of sentenced offenders is of almost importance, honourable members. I thank you.
Thank you very much. Any further discussion? The Honourable Dienda.
Thank you, Honourable Speaker. I just have a question to the Honourable Minister due to my experience that we had as the Defence Committee when we visited Zambia, and one of the Namibians was given the death penalty in Zambia. And at that stage, because the death penalty was still in force in Zambia, he was sitting there, he was not allowed. They didn't want him to be transferred to Namibia. Now with this protocol that you have placed here, in countries where the death penalty are still being practiced, what will the situation be for Namibians? Because here there's no death penalties, but in other countries it's practiced. So if a Namibian will receive the death penalty in another country, is there any way that that person can come to Namibia and serve 20, 30 years, or what is the arrangement in that case? I thank you.
Thank you. Next, Honourable Hanai Pondaka.
Thank you very much, Honourable Speaker. I stand to support this very important protocol. Being imprisoned on its own can already have a negative impact on somebody's self-concept, self-image, and it might even make it impossible or difficult for rehabilitation and reintegration into society. But for somebody who is incarcerated in your own country, an opportunity for family members, friends, and acquaintances to come to you, talk to you, visit you. I believe it will definitely work definitely after offending, a person go down. So, but that one will help a person to recover and regain your own self-concept and consider ourselves to be a human being again. And the process of rehabilitation might even be fast. Secondly, as my sister Dinda just said, other countries have got their own laws. What we don't do here might be done in other countries. We have a very good how do you call it? Correctional services in our country, which really works to rehabilitate, and the whole aim is correctional services for the people to be corrected. We don't kill, we don't, at least we have our own processes. So I really want to support this protocol. I cannot imagine a family member or a Namibian that you know who is in a prison somewhere without any contact and maybe without any hope for rehabilitation. So with those few remarks, I really support the protocol.
Thank you very much. Next, Honourable Maureen Indambwende.
Thank you very much, Honourable Speaker. I also just rise to support the protocol for its ratification, and also take the opportunity to appreciate the efforts of our Namibian Correctional Services in the effort of rehabilitation programs. However, in the motivation that was putting emphasis on inmates being closer to their families, I have noted or concerned that it's not necessarily the principle that we apply when within the country. So I also just want to say that within the country, it would be advisable, Honorable Minister, that we apply the same care in wanting people closest to their family. I'm talking about cases where for example, people are transferred far away from support, and even at times when I'm particularly focusing on an inmate I'm aware of that has got medical challenges that are wheelchair bound, and then it's still being insisted that he must be transferred further away from the family back to where he was in Marenda. So I think we do have inmates that suffer on our hands and does not get the same courtesy, even in cases where we have pregnancies in prisons. But be as it may, I just appealing that, because when you do a protocol, it's not only for the transfer, but it's also to establish compatible standards in the prison. So if we can apply back home what we extend for others. Thank you so much.
Thank you.
I support the certificate.
Honorable Dr. Albert Kawana.
Thank you very much, Honorable Speaker. I did not want to take part, but maybe just to assist my Honorable Deputy Minister regarding the question posed by Honorable Dienda. First, when it comes to issues of death penalty, there is nothing Namibia can do in such a scenario, because the laws of Zambia or another country which has a death penalty apply. The only difference is this: supposing Zambia is requesting an extradition of a person who committed a crime in Zambia, which has a death penalty in terms of the laws of Zambia, and that person is in Namibia, whereas the Namibian law does not allow or permit a death penalty per the provision of the Namibian Constitution, particularly I think it's Article 6, the Bill of Rights, the right to life. If I'm not mistaken, it should be Article 6. Now, in such a situation, Namibia can still extradite the person to Zambia on condition that in the event the courts or the judiciary in Zambia impose a death penalty, that penalty will not be carried out. That is normally how the situation is. But otherwise, in ordinary cases, where those countries have a death penalty, and the Namibian citizen is sentenced to death in those countries, really Namibia can do nothing other than maybe through diplomatic channels to plead for clemency and whatever, instead of a death penalty, maybe to impose life imprisonment. So, Honorable Speaker, I just wanted to assist my deputy on that score. But otherwise also maybe to say, really, Namibia is one of the most advanced countries, not only on the African continent, but also in the world, and more so in developing countries when it comes to rehabilitation. We are known to be one of the highest success stories, even by the United Nations. And currently now I'm happy to say we are going to receive assistance from the government of Japan, where they are going to sponsor a number of gadgets in the ICT field, which we are going to use, and we are going also to train a lot of our staff from the correctional service so that we can upgrade. Now, with regard to my SWAR, the Honorable Deputy Minister of Finance, you see, it also depends. Ideally, the policies, inmates must be as close to their families as possible. But when you do rehabilitation, sometimes there are some of those limitations. For example, motor mechanics maybe, which is only found in Windhoek. So the inmate who is incarcerated in Katima must come to Windhoek for rehabilitation in terms of motor mechanics or carpentry somewhere or bricklaying somewhere, because we have those centers. In such a situation, it may not be possible. Otherwise, I support the motion. I thank you.
Thank you very much. Honorable Sledbein.
Thank you, Honourable Speaker. I know we are over time. I'm very, very brief. I first of all support the motion. Just for clarity's sake, I need to ask the question that when we have ratified this convention, is it then binding on all SADC members to implement exchange of prisoners, or does it give guidelines on how a bilateral agreement is going to be effected so that we can implement that? So I would like to just get that clarity.
Thank you. Thank you very much. The Honorable Dr. Albert Kawana, that specific question.
Yeah, I rise really to recognize the issue very important raised by Honorable Schlettvine. You see, in terms of the SADC Treaty, ratification comes into effect when a prescribed number of states ratify. And once that is done, then it binds even those countries which have not ratified. And the beauty of this convention is that you don't have to go through the act which the Honorable Deputy Minister cited. Now you can use a convention to do that in terms of exchange of prisoners to serve sentences in their home countries. But now the number has not yet been reached. That's why Namibia, among other SADC states, were urged really to ratify so that the convention can come into operation. I so submit.
Thank you very much.
What is the required?
In the absence of further questions, Deputy Minister, you wish to reply?
I think all the questions are basically attended to by my minister, like the death penalty and Honorable Maureen, Hinda Mboinde, my apology. And then, of course, we have different programs throughout the whole country for rehabilitation. And, of course, Honorable Carlos, that one, you got the answer. It's binding. Honorable Ibn Doka, our correctional service aim is really to for a person to come out there as a productive Namibian. On that note, thank you, Honorable Minister, Honorable members, for your support.
Thank you. Thank you very much.
And also my minister to I have so many supporters here. The whole team behind me.
The whole house.
In solidarity, my minister, also thank you for your comments and thank you for assisting your deputy. Thank you.
Thank you. We are almost out of the time, and I'm just checking the front desk whether we are missing 2 members to be able to deal with this. So we have 3 items for for putting the question, and we can do that tomorrow. So I would like all of you to come on time. 4. Okay. Yeah. Huh? 4, yeah? 4. Yeah, yeah. Well, I was being reminded of the fact that last week we had 2 members who were not able to pay their respect to the founding father in terms of tributes. I was going to accommodate them at the tail end of this, but given the time now, I think we'll try and do that tomorrow. Do I have an agreement that we do that tomorrow? Now tomorrow, as you can see, we basically nearly exhausted the list, but tomorrow we can actually go for putting the question for the 4 items that we have, and we might even finish as early as possible. And I think it's important that we deal with the order papers as much as possible because our time is limited. So the House stands adjourned until tomorrow, the usual time.